So today we're going to talk to you about this law called Ferpa and how it applies to Ridge Road Middle School. Ferpa is known as the Family Educational Rights and Privacy Act, also known as Public Law 93-380, and it applies to schools that accept federal funds. So a lot of times you'll see charter schools and private schools that are exempt from this, and what it does is it guarantees the confidentiality of records. So we're going to dive a little bit into what that looks like in the classroom, in the district, and also at the state level. So before we even get into this, we need to talk about what student records are. And they are basically anything that can identify a student by name. This could be something as official as a record that's down in the main office that houses contact and address information, emergency contacts, talks about health information, IEPs, all could be grouped under that. But also something as simple as your grade book or your homeroom emergency contact information binder. Those types of things can identify students. As a classroom teacher, we need to make sure that we also understand that anything that demonstrates specific student progress. So for instance, if you're displaying work that may be outstanding but has a grade on it and it is attached to a student first and last name, so you know which student did that work and what their grade was, even if it's a perfect score, that's a FERPA violation. Because what you're doing is that you are putting that student's progress out for everyone in the public to see. So it's important to keep that in mind while you're displaying student work. Looking at rights, obviously parents have the right, parents and guardians have the right to see their students' records. But when you're looking at this from a globalized lens, so K-12, at the age of 18 or graduating, whichever comes first, the rights are transferred from the parent or guardian to the student. So someone like in my case who graduated a month and a half before I turned 18, even though I was 17 years old, those rights were transferred to me at that time. So I have control over my records, not my parents. It's important to understand that court orders a lot of times will tell you that even if you're a parent, that parent may not have custody. So a non-custodial parent may want to see a record and they may not have the right to see those records. So it's important, and we'll talk a little bit about the responsibilities that we have as classroom teachers, but also at the district and state levels, and how this looks at every level along the way. So let's start with the district. So the district has a responsibility by law that they need to notify parents of their rights pertaining to student records. And it's important to note that it has to be in their native language. So whatever that native language may be, the district needs to notify them, normally in the form of a letter, that states these are your rights as a parent when it comes to your student. So I'm going to highlight four very common rights that the parents have. Obviously the first being that they have the right to view the records at any time. They also have the ability to petition amendments. So a lot of times you'll see grades be challenged, or you'll see emergency contact information, or in the case of a divorced parent that wants to make a change to their guardianship, those can all be petitioned for change. Parents also have the right to file a complaint if they don't feel that the district is following the rules. So they can make a complaint at the state level. And also, parents have the ability to disclose certain information that may be in the best interest of their child. So, for instance, if you have a non-custodial parent that is in the picture, the parent that does have custody can let the district know, hey, I don't want this person to have information, because parents, when it comes down to it, have the right to say, you can see my son or daughter's information and you cannot. So that's important to understand as we move forward in this. So the school, when we're talking about official documents, obviously has grades, IEPs, 504s, the student's name, their address, the contact, the health data. A lot of times immunizations are in those records. the student's attendance data. A lot of times districts will have a copy of the birth certificate or a similar document that just certifies the birth of the child and the guardianship. All these types of things that are not public record. They're good. They're confidential, and the parent has the right to say who does and does not get a chance to see this. Now, there are exceptions to this. These exceptions typically you'll see school officials. So maybe the downtown EC department does not or wants to look at the procedures in an IEP meeting. That would be a reason to look at the student's official records. Very commonly you see students transferring from one school to another, and there's procedures in place for students that are transferring within the district and within the state and within the country, or even out of country for that matter. Court orders are very explicit. By that it means that it tells who can and cannot see this information, and a lot of times you'll see investigations, for instance, of a student who may have committed a crime, and a police officer would need a court order to actually look at the student records. A police officer does not have the right to come in and say, I need to look at little Johnny or little Susie's official records. They would need a court order to do that, almost like a warrant. But also with non-custodial and custodial parents. You may have a non-custodial mother or father who is trying to locate their child. They don't know where they are, or maybe they know the school, but they don't really know what the address is. That's a time when a court order would be put in place to deny a parent, or relative for that matter, access to those files. But in emergency situations, public safety officials may need or be required to look at these types of documents. When it's jeopardizing the safety of a child, they need to know where that child lives or where that child may be, or they need to look at the history of a child. Or in the instance of a health information where there might be something going on, they need to look at the official records. That would be a time when then they would be allowed to look. But regardless, the custodial parent or guardian has the right to say you can and you cannot look at my child's records. So that's very important to understand. This umbrella, it comes down to the parent saying you have the right, you don't have the right. Obviously a parent can't challenge a court order, but they do have the rights in other instances. So let's put all that past us now and look at the classroom in itself. And we already talked a little bit about displaying work with a grade on it. The idea in the classroom is that we need to protect any contact information for a student from plain view. You may have two students whose parents do not like each other, and that information may be out in the open. A grade book, for instance, or contact information may be out, and during a parent conference that parent could get that information and use it against the other parent or child. That would be a huge violation, and also would jeopardize the student's safety. So my suggestion to you is we never put grades in plain view. Even if they're digital, don't leave the screen up, because that is something that a student could access if they want to look on the computer. If you want to put up on your LCD projector showing students' grades, that's a FERPA violation, because everyone's grades are up there. So keep in mind that you don't have students even passing out progress reports or report cards, because they can look at each other's grades, and that again is a FERPA violation. You're violating that child's right to privacy in their confidential grades. The last piece of advice I can give you, and I'm going to share a story with you, is that when a parent is contacting you, and let's say it might be a parent or someone that claims to be a parent that you do not know, make sure that that parent has custodial rights. A couple of years ago I was faced with a parent in this exact situation, and I had a father that contacted myself and my team looking for information on his son. And I had never talked to this parent before, and I really didn't know. He was asking some strange information about his son's phone number for the mom and an address, and it just sounded really fishy, because he was also asking about attendance and exactly how many days his son had missed in school, and it was really a strange situation. So I actually forwarded this email to the mother, who I did have a relationship with, that I knew was the custodial parent, and just said, hey, the father is contacting me for this information. Do I have permission to give it to him? And with the suggestion of administration, was told that that's the route I should take, because again, it caught me off guard. And the parent actually came through and emailed our entire team and said that the father actually was a non-custodial parent, and he was actually looking for ways to gather information and use it against her to try and get her son away from her. So he was just using us as a pawn to try and get involved in all of this. So I was very gracious, and she was very gracious, and I was very grateful that I had gone that route, because if I had given that information, it really would have been a very detrimental thing for the child and the family. So always make sure that when you're giving information, that you know who you're giving it to. Always understand that. So just to wrap up, again, FERPA is designed to protect students, because during the school day, parents are transferring their custody to us as educators. During the school day, we are the ones who have to advocate for children. Their parents are not there to do that for them. And as minors, we need to have that responsibility to take care of them. Regardless if they're a behavior problem or not, we need to advocate for every single student under our watch. Remember that FERPA requires all districts to notify parents in their native language of all of their rights. And please, I can't say this enough, that always check with administration if you are not sure, to verify the legality of giving and releasing information. If you think or have an idea that this something might be fishy, don't give out information until you check to make sure. So this is just making sure that we have a clear line of communication between classrooms, administration, and the administration with the law and with the district and the state. So there has to be a clear line of communication. Everyone needs to have these conversations so that we make sure that we understand what is going on. And especially when you're disclosing information in public areas with other teachers. Many times when two teachers may be talking about a child during a home game, for instance, and there's a different parent that's listening, you never know who's watching and who's listening to you in the public. So be sure that you are always conscious of what you're saying, who you are saying it to, and who you're saying it around. The best course of action would be not talk about students at all outside of the schoolroom, classroom, and directly to the parent. So just keep that in mind. And again, if you have any questions, please contact administration. Contact me, John Neighbors. My contact information is John, John, .neighbors, N-A as in Apple, B-O-R-S, at cms.k12.nc.us. And feel free to just fire a question, and I can do anything I can to help you through the process if you do have a question. But again, your first line is always to check with your administrator. So I hope you have a great day, and I hope this makes sense, and best of luck in the upcoming year of teaching. I hope you all have a great day. Thank you. Goodbye.